Hi everybody, glad you're here. Today's topic is going to be forgery. Here is an essay hypothetical. Link is below as to what book this is from. This is about three people. Look at the very bottom line. It says, discuss the potential criminal culpability of Clyde, Tank, and Bob. Now, I am just going to focus on the forgery portion of this. If you want to pause it and read the whole thing, you can. But I'm cutting to the chase today, so I can keep this as succinct as possible. If you would please go to the second line. You can pause this and read the whole thing if you want. But at one point, a fellow named Clyde says that he will arrange to have a truck loaded, and he's going to alter the shipping records so the load wouldn't be missed. So basically, you've got three people that are trying to steal some whiskey from this distillery, and Clyde is going to get them to go along with this. Tank's going to drive the truck, and again, pause it, look at it, read it, and then I want you to ponder what you think the answer is and how forgery plays in. Don't just keep it on pause until you're ready to answer where the forgery fits in and who might be liable for forgery, if they are at all. Okay, now I'm going to the answer. Okay, here's the answer, and it is under Clyde. It says forgery occurs where the defendant has fraudulently made false document for the purposes of the crime, ordinarily viewed as a writing that purports to have legal significance, one that creates rights or obligations. The facts are unclear as to whether the shipping records that C altered purportedly affected the rights or liabilities. If these writings require Acme to deliver whiskey to be a forgery, now B is for Bob, they abbreviate everything. Anyway, they tell you to look at the Emmanuel Law outlines to get more details on that. Okay, we're going to jump ahead to some definitions, and then I'm going to give you a MBE, an actual MBE question that also involves forgery, and then we're going to discuss forgery a little more and what the right answers are in the MBE. Okay? Before we go to the next hypothetical, I'd like you to look at this particular page. I will put the link below. But I want you to look at the fact that forgery has a really long history, and there are three types of forgery or definitions. So this page does a very good job of discussing forgery. Excuse me, I've got a little cold. Now, in order for the judicial system to charge them, they have to have the elements. If one or more is missing, they can't. And here are the descriptions. You can read it yourself. Like I said, you know about uttering, I'm sure. But one of the key things here is legal efficacy. Not every altered document or letter falls within the bounds of forgery. In order for an altered document to be subject to forgery laws, the false writing must have had legal significance. It includes, but is not limited to, government IDs, deeds, checks, stock certificates, patents, wills, prescriptions, and it has to be a material alteration, and it has to be with the intent to defraud. And then the types of forgery: the signature forgery, the prescription forgery, the art forgery, the federal forgery. The most common forgery that is charged and prosecuted at the state level, however, certain types of forgery are considered federal forgery crimes. This includes, but isn't limited to, changing or altering government-issued IDs, changing or altering other documents in an attempt to steal another's identity, changing or altering military documents, immigration documents, anything to defraud the federal government. So you can look through here, but for the purposes of exams, you're going to want to know that they're going to have some of these subtle issues. Now, the next question that I'm going to go over is an MBE. The last one was a essay. The MBE question is taken from an actual MBE, old MBE, and it is in a book. I'll be right back. That we have one of the hypotheticals we're going to discuss. Here is a website that has a definition of forgery. The crime of forgery generally refers to the making of a fake document, the modification of an existing document, or the unauthorized signing of a signature without authorization. The elements of forgery involves false document, signature, or other imitation of an object of value used with the intent to deceive another. Those who commit forgery are often charged with the crime of fraud. Documents can be the object of forgery include contracts, identification cards, legal certificates. Most states require that the forgery be done with the intent to commit fraud or larceny. The most common form of forgery is signing someone's name on a check. Objects, data, document can also be forged. Legal contracts, historical papers, art objects, diplomas, licenses, certificates, and identification cards can also be forged. Currency and consumer goods can also be forged, but this crime is usually referred to as counterfeiting. Forgery requires deception. And then forgery as identity theft. Now, I'm going to put the link below. If you want to read the whole thing, you can. The other thing that goes hand in hand with forgery is uttering. Uttering is a crime involving a person with the intent to defraud that knowingly sells, publishes, or passes forged or counterfeited document. More specifically, forgery creates a falsified document, and uttering is the act of knowingly passing on or using the forged document. So here's what we have. Now, I've got a hypothetical here. Whoops, that's not the hypothetical. That's a reference book that I was putting in the links. Here it is. Okay, this book is called Strategies and Tactics of the MBE. I have the hard copy, but I found this here, which would make it a lot easier for me to just than taking my phone and taking the camera on it. So it says, appreciate the hidden issues, causation, and intent. MBE questions rarely focus on obvious issues. That's why it's important to know the elements of the crime flawlessly. Even if you do, though, it's easy to miss issues, as the following question illustrates. Okay, so here's the question. Now, I'm going to read it to you. An antique dealer who was a skilled calligrapher crafted a letter on very old paper. She included details that would lead knowledgeable readers to believe the letter had been written by Thomas Jefferson to a friend. The antique dealer, who had a facsimile of Jefferson's autograph, made the signature and the other writing on the letter to resemble Jefferson's. She knew that the letter would attract attention of local collectors. When it did, and she was contacted about selling it, she said that it had come into her hands from a foreign collector who wished anonymity, and that she could make no promises about its authenticity, as she had adopted a collector paid her $5,000 for the letter. Later, the collector discovered the letter was not authentic, and the handwriting analysis established that the antique dealer had written the letter. In a jurisdiction that follows common law definition of forgery, the antique dealer has A, committed both forgery and false pretenses, or B, committed forgery because she created a false document with the intent to defraud, but has not committed false pretenses since she made no representations as to the authenticity of the document. C, not committed forgery because the document has no apparent legal significance, but has committed false pretenses since she misrepresented the source of the document. D, not committed forgery because the document has no apparent legal significance and has not committed false pretenses since she has made no representation as to the authenticity of the document. So what do you think the answer is? A, B, C, or D? First, you eliminate wrong answers. Then you look at the two remaining answers and pick the best of the two. The subtle issue here relates to the definition of forgery. Forgery can only occur with respect to a document that has some apparent legal significance. For instance, the document represents a right to payment. Now, this is at common law, or indicates the title to property has passed, a deed, or purports to show that a contractual obligation is owed, a signed contract, or the like. Where the document, when viewed on its face, and whether fake or genuine, does not purport to have legal significance, it can't be a forgery. But even if it is counterfeit, since even a genuine letter by Jefferson wouldn't have present legal significance, faking it can't be a forgery. But using the fake to exchange it for money would be false pretenses. So, because of the subtleties in the definition of forgery, C is the correct answer. Let me read you C. Not committed forgery because the document had no apparent legal significance, but has committed false pretenses since she misrepresented the source of the document. And if you look at the very beginning, it says, in a jurisdiction that follows common law definition. Okay, we're not just talking about forgery by code law. We're talking about forgery at common law. And that is another subtle distinction you need to keep in mind. So the correct answer is C. Another issue that can trip you up is intent. You need to remember how intent applies to different crimes. For instance, notice intent affects conspiracy, accomplice liability, larceny, and robbery. In conspiracy, the conspirators must not only intend to agree, but must also intend the criminal goal of the conspiracy. For a defendant to be liable as an accomplice, he must intend. And you can get this book, or you can pause it a little and look at it, but I'm not going to go on and on. I wanted to give you two questions that involved forgery, and I wanted to let you understand what it meant with some examples, and I think we've done that today. You can pause it and review it, and there are other videos that explain details of conspiracy and intent. Thank you for your time. Please like, share, and subscribe, and have a great day.